The Liberal government has taken a second go at tackling harmful online content. The new legislation tabled just this afternoon seeks to better protect both children and adults on the internet. It proposes establishing a digital safety commission, a 5-person panel tasked with enforcing new rules around harmful content, as well as a new digital safety ombudsperson. The bill also seeks to amend the criminal code to crack down harder on hate crimes. Arif Virani is the minister behind that. He's the Minister of Justice and Attorney General of Canada, and he joins me now. Minister, thanks for taking the time today.
Thank you for having me.
So this bill emphasizes measures to protect children. It promises a digital safety commission and a digital safety ombudsperson. Walk me through that. If I'm a parent who doesn't like something that my kid sees, how do I go through the process and how does this make it better for them?
So the message that I have for parents, and I include myself among them, I've got 2 youngsters at home, is that there's a lot of scary things out there that are on the internet. And what I find troubling is that there's more rules for my son's Lego than there is for the most dangerous toy in my home and in every home in this country. And that toy is the screen that your child is on right now, whether that's a phone, a tablet, or a computer screen. And we are changing that with this legislation because protecting kids is fundamentally what this legislation is all about. There is a duty to have content removed within a 24-hour window of content that would exploit a child sexually. That is critical because of what is happening right now online is that there are sexual predators and pedophiles that are seeking to reach out to our children, unbeknownst to us very often. And what I find troubling is that for a long time people have said to me, well, Minister Virani, isn't that a problem with parents? Shouldn't parents be addressing this themselves? Why do we need to have more aggressive rules about what is happening online? What I say to that is that just like every other parent out there, I tried and hopefully successfully have taught my kids how to cross the road, looking left, looking right. But I also know that there are rules of the road. There are stoplights, there are stop signs, there are red lights, there are speed limits. Right now you can empower your kids till you're blue in the face about the dangers that lurk online. There's not enough rules for what's happening online. Look, with this law, we are changing that.
Taking down child sexual content, exploitative content, revenge porn, unauthorized leaks of private, intimate material. No-brainers in terms of it needing to be addressed. But I want to understand the process. You're creating a digital commission. You're creating a digital ombudsperson. How do they work? Like, do I complain to Meta? Do I go to the digital ombudsperson? Do I go to the commission? How does this framework, how do you envision it working to make things safer for people?
Okay, so the second component of the bill, and I'll explain it for you, David, is that we're also empowering the adults, including those parents. So they've got different avenues now. They've got an avenue where they can raise the material by a flag or a signal to the platform itself, or they can raise it with the new digital safety commissioner, who then raises it with the platform. Mm-hmm. So there's harmful content that it goes beyond what you just mentioned with respect to
the commissioner or the ombudsperson? Sorry to...
The commissioner.
Okay.
Commissioner. The ombudsperson is meant to be a bit of a concierge, helping people navigate the system, figure out their rights, figure out their avenues and their recourse. The complaint would be raised with the commissioner, but you can flag the content, you can complain about the content. That requires a response on the part of the platform. The platform has to address content that could be used to bully a child, mm-hmm. content that could be used to induce the child to self-harm. We know exactly what happened. You probably covered it, David, in BC 2 months ago with that little child who was sextorted. We know that he had nowhere to turn and ended up turning on himself, and that child is no longer with us. It's kids like that that are motivating us to take action. It's kids like that that have to be top of mind for the platforms now, because when they're forced through this legislation to file a digital safety plan, that means they're going to take measures to reduce the risk of child bullying, of child self-harm being propagated on their platforms. They got to show how they're moderating that risk, and if they're not meeting their own terms, they will be held accountable by that new digital safety commissioner, including with very hefty fines, the likes of which we've not seen in Canadian legislation.
Okay, so those fines are up to 6% of global revenue, which is massive money, as we know with these companies. So, Minister, what is the threshold by which Elon Musk or Mark Zuckerberg could have their company fined to such an extent by the Canadian government, and how do you enforce it? What would they have to do? It just appearing on their platform, I assume, is not the threshold. It's whether they take it down timely fashion. How does it work there?
So the takedown relates to those first 2 categories of child sex exploitation and the issue of revenge porn, the sharing of intimate images without consent. The aspect of sort of ensuring that the risk is reduced across the other 5 categories relates to the Digital Safety Commission. What I would say to you is that it's important in terms of that question, David, because it's not the Canadian government finding people, it's the Digital Safety Commission making that determination. And what we've done is entrench in law a fine that is significant enough that it changes the economic calculation. Everyone watching right now knows that what is driving and being prioritized by the platforms right now is a financial imperative. What we're saying is that that is no longer sufficient. You must have Canadian safety as important to you as your financial imperative, which is driven by advertising revenue, which is driven by clicks and driven by eyeballs on screens. The status quo is not sufficient. We are asking those platforms to work with us in terms of these digital safety plans or face consequences that can be as high as that 6% of global revenue. It's set that high because these are large international entities with very large amounts of revenue. We need to set it at a level that will get the attention of these platforms.
But just what triggers the penalty? Is it a refusal to deal with it within the prescribed timelines? Is it refusing to take it down entirely? Like, I understand some of the other things that are not subject to a 24-hour takedown because they can be a subjective argument around them. Child sexual content, no subjectivity there. But what is the standard for a fine?
So the standard for a fine would be set by the Digital Safety Commissioner, subject to the parameters that are in the legislation, but it is failure to comply with one's own digital safety plan. It is failure to comply in the first two categories with the automatic takedown requirement. So they are significant and they are meant to ensure that there is cooperation on the part of the platforms. We want the platforms to be working with us. Let me be very clear about this, but this is really important to understand that trust and safety divisions are a mishmash across the various platforms. Sometimes we've seen reductions in people that are working on things like content moderation. What we want to ensure for Canadians is a uniform playing field vis-a-vis these platforms that are scoped in and that are covered by the Digital Safety Commission. And we believe that will do so in a manner that ensures the safety of our kids and the safety of adults and the power of adults. The other thing that's really critical to understand, David, is that people talk to me about freedom of expression. I'm duty bound to defend that and always will. It is a charter protected right. I swore an oath to uphold the Constitution. But what I also explain to people is that right now, a lot of what you put out to the world and also what you receive in terms of your feed is being decided for you. Not by a government, but by a private company. That private company is making decisions behind closed doors. We don't know what decisions they're taking or why they're taking them. That will change by forcing them to provide a digital safety plan that exposes and provides transparency about the decisions they're taking that affect your and my free speech.
But you're bringing in this Digital Services Commission, Digital Safety Commission, excuse me, that you'll be appointing, not you, the government will be appointing. So how quickly will that be in place, and what is the criteria by which you're going to pick people to take on this regulatory oversight and enforcement role?
So the first step is we've tabled the law today. We're going to have parliamentary debate about it, go through committee, ensure that if there's tweaks that need to be made to improve the bill, that we are doing that. We get it through the Senate, we get it to royal assent. Then comes the work of implementing the actual commission. There are components in the bill that will take place quicker in terms of changes to the Canada Human Rights Act, changes to the Criminal Code of Canada. What's important is that in terms of sort of the people that staff that commission, those people will be critical. It is not lost upon me that we need to not only have this legislation, have this new commission, but we need to have Canadians have confidence in that commission. One way that we're going to do that, David, is critical, is that the selection of who is the chief of this new commission, a very important role in Canada, that will be decided in the chamber right behind me. A House of Commons vote will be held on who that commissioner should be. That will be also voted on in the Senate. We want parliamentarians to weigh in on such a significant role because all Canadians need to have confidence in that person via their elected representatives passing a vote in their favor.
So Minister, this is an online harms bill, but it's also a criminal justice bill. You're creating a standalone hate crime provision in the criminal code. So, for example, you referenced the London attack on the Ufsal family. That could be prosecuted as a hate crime from the beginning, rather than taking into consideration at sentencing. So I understand that aspect, and you spelled that out clearly in the news conference we carried earlier. What I am less clear on are some of the criminal code amendments for things like promoting genocide, the hate speech provisions with sentences to be carried up to life in prison. Now, you said earlier that's to give judges a broad range, that the 5-year maximum was too limiting. You want to be able to give them up to life in prison. But what do you envision as a sort of a speech offense that could lead to life imprisonment? And I don't say this to defend the right to advocate for genocide, but I'm trying to understand the criminal law implications of what you're proposing here as legislation.
Well, I'm not gonna speculate about specific context. That's for an individual judge to determine. But let me just give you a few sort of aspects to your question. The first is that judges have a range of sentencing, right?
Yep.
And what we're doing is we're saying that the current maximum end of the sentence for an individual who could be found guilty of advocating or promoting genocide is 5 years if they proceed by way of what's called an indictable offense. And what we're saying is that that limit is not high enough. We need to denounce at the highest level the actions of someone who would be promoting or advocating genocide. It is one of the most heinous crimes known to mankind. I think that's important, particularly in the climate that we are now in. The second component I would say to you is that it's important, David, that people understand this is not something that myself or some individuals of the Department of Justice are sort of conceiving sort of on the fly. What we're talking about when we talk about genocide is established jurisprudence on genocide, the same way there's established jurisprudence on what constitutes hatred. This has come up in terms of questioning about what hits the level of hatred. We are entrenching a definition and codifying it, a definition that already exists in the Supreme Court case law from a decision called Whatcott, which dates to 2013. That's critical because it talks about detestation and vilification, which is a very high standard. There will still be expressions that are insulting, hurtful, and offensive to you and I that circulate. That is what the constitutional protection on free expression protects. It does not protect talking about violence and violent speech, which is expressions of detestation.
Understood, and I understand the importance of the justice system in denouncing certain acts as unacceptable society and sending a clear message with a penalty, but you must envision something behind a life sentence, or how did you come up with this notion that it needs to be up to a maximum of a life sentence? Why not 10 years? Why not 12 years? Why not 15 years? To go to a life sentence, we apply that to things like murder, terrorism charges, for example. Like, there are very specific offenses that we envision for something like that. What did you envision as you drafted this bill to put this new penalty into the criminal code?
What I would say to you is that genocide, by definition, is looking for the extermination of a group of people, right?
But what's the speech? What's the speech that would lead to this?
What I would say to you, David, is that with respect to that is not for me to opine upon as the Minister of Justice. It is for a judge to make a determination that is case specific. But what I know in terms of what we've done on the extensive consultations on this bill is that we needed different components, a civil component with the Commission. We needed the Canadian Human Rights Act to be amended, and people who we consulted with also said to us quite clearly that criminal code provisions need to be enhanced. Our provisions also include a new peace bond, which would be available to prevent an individual on a prospective basis from committing one of the hate propaganda offenses or the new freestanding hate crimes offense, to ensure that that person has to keep the peace and be of good behavior. We're trying to be proactive here in terms of stopping the radicalization and the hatred that we are seeing currently in Canadian society. And these provisions and these amendments will give law enforcement the tools to do just that.
Okay, as a final point, I'm hoping you can provide an additional piece of clarity because we've got to let you go. But you say you wanted these changes because of what is happening in the country right now. And we see the protests sparked by this conflict raging in the Middle East right now. And we do have groups that argue that the pro-Palestinian chant of "from the river to the sea" is a call for genocide. Palestinians would disagree with that and say that is an expression of liberation for the rights of their people. But where does something like that fit into this legal framework and speech framework you've rolled out today, and in terms of how judges and where you're trying to denounce? Is something like that what we're talking about here, or is it much greater and higher level than that particular phrase?
So individual determinations will be decided based on the context of specific cases by the judge that is making those decisions, David. What I would say to you is that our denunciation of hatred, including the hatred that we're now seeing around the country, is strong and it is resolute. You know that there is a Holocaust denial offense that is entrenched in 319 of the Criminal Code right now. You know that at that press conference that I was just at, we had both the National Council of Canadian Muslims and the Centre for Jewish Israeli Advocacy standing side by side behind this important legislation. Those are the types of people that have talked to me about the fact that we need that peace bond. We need the freestanding hate crimes offense. We need to enhance the maximum penalties for the hate propaganda offenses. We are resolute in our determination to see the hatred abate in this country. And more importantly, on the civil side with that commission, what we will do is get right at the heart of that Afzal trial that just concluded last week, which is that the radicalization that people are learning about online has real world consequences, including the fatalities of Canadians. That's what we have to stop, and that's what we're going to start stopping by ensuring that hatred is being addressed buy in the online space to keep Canadians safe.
Okay, Minister, there's a lot in this bill I'd like to ask you about, so I'm going to invite you back on another day when you have time, because there are other components we didn't even touch on in this, but I want to thank you. That's Arif Virani, Minister of Justice and Attorney General of Canada.
Thank you, David.
All right, for more on this, specifically the online harms component, Emily Laidlaw is a Canada Research Chair in Cybersecurity Law. She also co-chaired the expert panel appointed by the federal government to advise on next steps for the development of legislation to address online harms. So Emily Laidlaw, when we spoke last week, you emphasized the need for online harms legislation to be narrowly focused. It seems like they've tried to go in that direction. What did you think of the balance the government struck when they laid this out today?
Yeah, I mean, I would say that all around, I'm really pleased with it. I think that they took a really measured approach. And my concern was I want some effective solution to reducing harm online, and I want to safeguard fundamental rights. And that happens in sort of small places throughout the legislation that are really key. And I think, for one, content removal is really only focused on those, the things like child sexual abuse images and intimate image abuse. And otherwise, it's about risk management techniques. It's about digital safety plans and sort of in the direction of online harms reduction. So I was happy with that. I would say that there are going to be some controversial aspects of this that not everyone's going to be happy about. So, for example, private messaging is out. If you talk to many, who study extremism and in the child protection community, they'll talk about how that's such a key vector for communicating extremist messages and child sexual abuse material. But that's just one of those wicked problems where there's so many security and privacy risks at the same time that there's harms. It makes sense that the government here maybe took a more measured, narrow approach at this time.
So just on that point, do you think that potentially moves the problem from the platforms that are being regulated, maybe more into like deep, dark, ugly WhatsApp and Signal chats from maybe other parts of the internet? Is that what we may see happen here as a result of this?
I mean, we're seeing that now anyways. And I think that no matter what we do, this is going to be a whack-a-mole game. But the problems with private messaging, I think we're such a challenge that it makes sense right now to take on the larger platforms to look at developing those safety plans. I think that there were key free expression language throughout the legislation, although, I mean, I will be making recommendations about how they can strengthen aspects of that. One thing I would note is that this commission, from what I have read in the legislation, looks independent. It's also 3 to 5 commissioners, at least in that one particular body. Right. And they have the power to make regulations and impose fines. So it is, to my mind, almost operates like a tribunal separate from government, which I think is important. And I was a little nervous when I saw that it would cover bullying and similar, because we cannot have a regulator out there tackling hurt feelings, even for children. But if you look closer at the definitions in the legislation, it's very tightly constrained. It's more similar to the Australian legislation. You're looking at real serious harm to children that is linked with, intentional threats or intimidation or humiliation. Similarly, hate propaganda is very narrow. It's the Walcott standard. It's been set by the Supreme Court. It's a high threshold.
Yeah, I mean, these platforms, and I don't say this pejoratively, but they have far more power and far more reach and far more connection with individuals than traditional broadcasters ever had. And they gained all of that without the sort of oversight and regulation and slower pace of growth that television and everything else went through. So we have this situation where they are creating this commission. They are looking at these other things. But I wonder if you have ideas on. The legislation includes amendments to the Human Rights Act that allow people to file hate speech complaints to the Human Rights Commission. There was an insistence that this is not about curtailing freedom of speech and individual expression, but human rights commissions and some groups who advocate strongly for free speech. That's a collision course, it seems to me. How do you think that's potentially going to play out?
Yeah, and I have advocated separately that we did need to reintroduce Section 13, and I am sensitive to, and that would be the Human Rights Act, making complaints to the Commission. I'm sensitive to the fact that there's a risk of too many complaints, worries about the standard. Again, this is an issue really of implementing the Walcott standard that is, you're looking at delegitimizing an entire group
Sorry to interrupt you. Just explain that standard. Explain that to an audience at home that doesn't know this. The Walcott standard that you're outlining. What are we talking about there in a nutshell?
Yeah. So let me just say in a nutshell, it means that offensive expression, even repugnant expression, is protected.
Right.
It is only when it rises to the level that it is basically a disdain and dehumanizing to the extent that you are basically not recognizing an entire group of individuals that it hits that standard. So if there's a failure of a tribunal hitting that standard, then that's something that should be appealed to the courts. Mm-hmm. But I will say that many victims don't want to go to law enforcement. This is too much for law enforcement. So we need to save their resources and efforts for some of the kind of, I would say, it's not the right language, but the higher ticket items where they can investigate in particular cases and where incarceration might be appropriate. But at the moment, there's nothing else available to individuals, because if it's online, then generally that would be a federal Human Rights Commission matter. So we needed that provision reintroduced. And I think that it's valuable to define hatred in the criminal code as well, just to make clear what it means when we're talking about hate.
Some of the sentences, though, in the criminal code, because this is an online harms bill, but it's also a criminal justice bill. When you look at these provisions, and I suppose the two have to go hand in hand, given the nature of the challenges they're trying to deal with here. But some of the penalties for propaganda-related offenses, we're talking about up to lifetime in prison. And the minister, they have a reason for putting it into the legislation, but he says the specifics have to be envisioned by a judge dealing with specific cases. What sort of examples do you think we're talking about there with that such a serious penalty for a crime of speech?
No, and I watched your interview of the minister, and I find it difficult to even contemplate what scenario would be appropriate where you would be incarcerated for life for the things that you say. I am generally in favor of leaving it to the discretion of judges. They are in the room. They can assess what the appropriate penalty is in those circumstances. But I can't even really, I can't speak to the appropriateness of a life sentence in particular when I can't in my mind even think through a scenario where that would be appropriate at the moment.
That's what I struggle with, and it feels like that could be something politically they're going to have to deal with, but you're not here necessarily to talk about that. I mean, so it's tabled, and it's going to go through the legislative process. There was preemptive opposition from the opposition last week about this. There has been some criticism from the New Democrats that they're not going after the algorithms of the companies in their legislation. I don't know if that's something that can be dealt with through regulation, and maybe needs to be done more nimbly that way. What do you hope to see next from the government of this? What do you need to see next from the government on this as someone who's consulted on this framework?
Well, I think that they need to break down the details of how this would work from A to Z. Where is the victim in this? What happens to them when something horrible takes place online, and they need to figure out how to navigate that. In particular, it is unclear to me at the moment what the role of the ombudsperson is, besides kind of working with communities and navigating those issues. I think that should be developed and explained further. I think that there are some specific points I want to know more about. So, for example, it seems that gaming is outside the scope of the legislation. And that is interesting to me because that is one of the key harmful, spaces where harms are happening to children online.
Right.
Again, it's as early times. I'm waiting for the technical briefing to find out more detail on that one. But I think that we need step-by-step understanding. If you take a typical victim in these scenarios, how would this work and what safeguards are in place to ensure that ultimately, if you're on the fence, we need to be landing on the side of freedom of expression.
Emily Laidlaw, we appreciate your time. It's Emily Laidlaw, Canada Research Chair in Cybersecurity Law. Thank you so much.